Good afternoon. Welcome. I'm Bill Brubaker, the Dean of the University of Alabama School of Law, and it's my honor to welcome you to our inaugural Attorney General Luther Strange Public Service Lecture. Before I do that, we have a number of distinguished guests that I want to recognize today. First, Judge Edmund LaCour, recently appointed judge to the Northern District of Alabama and former Solicitor General of Alabama. To his left, our state's Attorney General, Steve Marshall, our graduate in the class of 1990, I believe. That's correct. We are, one of the other special things that I will note about today's lecture is we have some people that are joining us online today from around the country. Other folks in state attorneys general's offices, and we're delighted to have you with us. We hope that many of you in future years may be able to join us in person. So I want to welcome you virtually to our law school as well. And of course, I'm grateful to students, faculty, staff, and folks from the university and Tuscaloosa communities for being with us here. We want to extend to you a warm welcome as well. The Attorney General Luther Strange Public Service Lecture is a new annual tradition at our law school, made possible through the generosity and commitment to public service of Alabama's former Attorney General and United States Senator Luther Strange. Mr. Strange received both his bachelor's degree and his law degree from Tulane University, where he attended on a basketball scholarship. Before he entered public service, General Strange was a partner with the law firm of Bradley, Arant, Bolt, Cummings. And while there, he led the legal team that brought Hyundai's first North American plant to Alabama back in 2002. Especially significantly, though, for today's purposes, Luther Strange served as the 47th Attorney General of Alabama from 2011 to 2017. In that capacity, he led Alabama's law enforcement efforts in areas ranging from public integrity to major multi-state litigation. His tenure was marked by a strong emphasis on combating public corruption, and he and his team secured more than 24 convictions of public officials, including perhaps most notably the conviction and removal from office of the Speaker of the Alabama House of Representatives. He also successfully argued the First Amendment case Lane versus Franks before the U.S. Supreme Court. And following the appointment of Senator Jeff Sessions as Attorney General of the United States, Strange was appointed to represent Alabama in the United States Senate, which he did during 2017 and 2018. Our law school is grateful to General Strange for his generous engagement with our students. For a number of years, he has taught a class here called Litigating with the Power of the State, the Role of the State Attorney General. I suspect some of his students are here today, and we are delighted about that. And today we are even now further in his debt with the establishment of the Attorney General Luther Strange Public Service Lecture. The lecture's purpose is to create a forum where distinguished public servants can speak directly to our students, faculty, and broader community about the challenges, opportunities, and ethical demands of public life. Each year, we hope to bring to campus a figure whose career embodies a deep dedication to the public good, and these lectures, we hope, will allow us to reflect on the vital role lawyers play in protecting the rule of law, addressing complex societal issues, and contributing meaningfully to civic life. This series is designed not only to honor accomplished leaders, but I'm looking at you, Alabama law students, to inspire future leaders as well. I'm about to call on General Strange to introduce our inaugural lecturer, Tennessee Attorney General and reporter Jonathan Skrmetti. And I won't steal his thunder, but I will say, General Skrmetti, it's a great honor and pleasure to have you with us today. We're delighted to have such a great choice to kick off this lecture series. We appreciate your being with us. Following the lecture, General Skrmetti has agreed to take your questions as time permits. So please be thinking about what those questions might be. And I will just, as a housekeeping detail, remind you that if you want your question to be heard, both in the room and by our guests online, please use the buttons on the microphones in front of you so that we can hear the questions that you ask. So let me now call on General Strange to introduce today's speaker. Would you join me, though, in welcoming and thanking Luther Strange?
Well, thank you very much, Dean Brubaker. I am very grateful to you and to the entire law school community for allowing me to establish this public service lecture series. As an adjunct professor, here I've had the pleasure over the past 4 years to get to teach and work with some very bright and talented law students here at the law school. You know, I've been very fortunate in my legal career to practice in a large corporate legal department, to be a partner in a major law firm, and to establish my own small law practice. But the most rewarding legal job I've ever had was in public service as Alabama's 47th Attorney General. My hope is that our speaker series will inform and inspire you, our law students, to consider public service at some point in your legal careers. The state needs it, and I promise you will not regret it. And there's no one more suited to be our inaugural speaker than Tennessee Attorney General Jonathan Skrmetti. Thank you, General, for being here with us today. Prior to being sworn in September of 2022, General Skrmetti served as Chief Counsel to Tennessee Governor Bill Lee and as Chief Deputy Attorney General to his predecessor, Attorney General Herbert Slattery. His other experience includes a decade as a federal prosecutor in Memphis, work at the Department of Justice, and as a partner in the law firm of Butler Snow. General Skrmetti holds honors degrees from George Washington University, University of Oxford, and Harvard Law School. He also clerked for Judge Stephen Colleton on the U.S. Court of Appeals for the 8th Circuit. I'm so proud to introduce him as our inaugural speaker. General Skrmetti.
Thank you. It's an honor to be here today to deliver the inaugural Luther Strange Public Service Lecture. Luther Strange is a great American and a great Alabamian, and I'm proud to call him my friend. He's been generous with his time and his wisdom with me, with many of the people in this room, and with people across the country and across the state, and I will be forever grateful. I hope that this speech is a worthy start to a grand tradition to be carried on in your name, Luther. Dean Brubaker and your esteemed faculty, thank you for your hospitality and for this opportunity. And thank you for the great students that you have sent to the Tennessee Attorney General's office. We are still hiring. That will be a recurring theme throughout this talk. So if you are a law student, pay attention to that. And honored judges, thank you for your commitment to public service and your ongoing devotion to learning about the law. And finally, I want to recognize my friend and mentor and colleague, Steve Marshall. Steve was my guiding light in AG world when I took office. He is a model of integrity and capability. And in particular, he and his team did an extraordinary job defending Alabama's law protecting kids from gender transition procedures that were irreversible. His litigation and his amicus brief were indispensable components of the national win on that issue. So thank you, Steve. It's great to see you here. I am particularly excited to be in Tuscaloosa because here, more than anywhere else in the United States of America, you appreciate a Croatian American in a leadership position. Yeah, I'm a little bit of a mutt ancestrally, but the unusual last name attests to my roots in Croatia by way of Biloxi. There are not many of us Skrmettis. Growing up, it was a challenge to explain to people how to spell it, but I'm guessing in this room, most of you probably know now. You know, and I think about my forebears who came over from Croatia, from across Europe, others who came before them to a young colony and fought and died for independence. others who came before that to a wild frontier to carve out a new home, and people long before that who walked here across Beringia before the first stone was raised at Göbekli Tepe. Countless people who made extraordinary sacrifices to build a better life for us who came after them. Ancestors and others who gave their lives or endured misery and drudgery or fear to give the next generation a fighting chance. And we have come so, so far. At night, we don't huddle in a cave relying on fire and spears to protect our children. In the day, we don't view every encounter with a stranger as a serious risk of violence and death. We have cozy houses and decent schools and streaming video. We have health care and movie theaters, interstates and airplanes. And while we remain far from heaven here on earth, we are living lives far beyond the wildest dreams of our ancestors. And so much has gone into getting us here and keeping us here. There is so much to appreciate. And one key innovation refined over the millennia that's led to the unprecedented human flourishing of today is the rule of law. It's telling, for instance, that so much of the Pentateuch, the first 5 books of the Bible, focuses on the law. It's because the law is a foundational infrastructure. It creates and maintains the conditions for people to succeed at everything else they want to do. The rule of law lets us resolve our disagreements in a generally predictable and transparent process. And that leaves us free to get over whatever the current disagreement is and move on to whatever the next disagreement is. This applies to both individual disputes we may have and to the greatest debates of policy and law. And I emphasize this point because there's been talk lately highlighting the Hobbesian violence underlying our modern niceties. We are reminded that in the real world, strength and power prevail, and our laws and mores are an artificial barrier between us and a world of existential violence. But of course, that is entirely the point. Under the rule of law, we mitigate the exhausting Nietzschean struggle and give everyone the opportunity to focus on building. Our forebears dragged us out of war of all against all, and we are profoundly better for it. And it's true that if our institutions break, we'll be back in a more savage state. But that fact demands that we do everything we can to reinvigorate those institutions rather than hasten their demise. We have an obligation to the people who came before us and to the generations that will follow us to reinforce the rule of law and leave our country better than we found it. So how do we do that? Well, to reinforce and revitalize the rule of law in America, we have to understand it. The most fundamental principles of American government are popular sovereignty and separation of powers. Everything in American law is downstream of the consent of the governed. The animating force behind every legal authority you encounter is ultimately the American people. This was often glossed over in my legal education, but it's critical to understanding the bigger picture. In my day, we focused on the common law, which centers judges who are using their discretion and their reason to discern and apply rules. And in this model, the font of law is robed gurus, no offense, your honors, imposing their wisdom on the needy masses. You can call it the Neoplatonic approach to law. And the common law was a glorious development in its day. It offered a path to enduring principles and predictability. Judges did their best to get the right result one case at a time, and over time, these decisions accreted into rules that made sense and provided predictability in the law. And this constituted progress. But the common law approach emerged at a time when the sovereign was one guy with a penchant for violence. Giving judges latitude to innovate in that context promoted liberty. The same mindset translates poorly to our constitutional republic. The sovereign now is the American people. The Constitution and laws of the United States reflect the will of the people. Judges still play a necessary and important role in our legal process, but a judge creatively resolving disputes by creating new rules is no longer a restraint on the arbitrary will of a could-be tyrant. Instead, it's often an elitist restraint on democracy. And to be clear, I'm not talking about judges untangling a mess of contradictory statutes or delineating the edges of a constitutional right. That's what judges do. That's what courts do. But what harms our country are elite constraints on democratic processes that appear invented out of whole cloth. Law not of the people, by the people, and for the people, but imposed on the people. Judges determining out of the blue that our long-standing immigration laws are functionally unenforceable. judges determining that our devout church-going forebears actually baked into the Constitution sweeping victories for the other side of a culture war that had not even started when the document was ratified, hiding expansive rights to abortion and gender fluidity that went undiscovered for centuries, judges invalidating laws that keep kids away from sexually explicit material, while in parallel, other judges vigorously affirm laws that prevent parents from keeping their kids away from that material. Judges who pick and choose the beneficiaries of what are supposed to be universal laws against racial discrimination. And it's true, such decisions are often salvaged on appeal or on cert, but persistent pressure from the lower courts can nevertheless distort the law by overwhelming the system's capacity for error correction. This all contributes to a more general resentment that the law is getting stricter and stricter for the people who follow it, while those who break the law have an easier and easier time. And just compare, if you will, the treatment of a small businessman with an illegal immigrant or a schizophrenic felon. Now, all three of them are people of equal dignity who deserve the respect of the law, but the standard and the approach of the system to one is very different than the others. And America needs that small businessman to contribute both as a thoughtful voter and as a productive job creator. If the small businessman loses faith in the country, we are done. Now, just because constitutional guardrails do not mandate a progressive victory on cultural issues doesn't mean a conservative victory is preordained, but it does guarantee a victory for the democratic process. Instead of having a tiny group of robed magi dictate the law, the people have to engage with one another and arrive at the answer. Each side brings its best arguments, and if there's no clear winner, they find a compromise, or they keep trying to win. They try to win over adherents through either argument or election. And there's an empirical component there too. If things don't work, if the answer they arrive at is the wrong answer, they can go back and change it. And when an issue is resolved, then everyone moves on to the next argument. And I want to emphasize this point because it's the heart of the matter. The rule of law means that we have a way to resolve disputes so they don't consume us. Back at the end of the 19th century, the nation was torn apart for decades over the free silver movement. Decades. Fraternal orders were spawned, people named their kids after prominent figures involved in the dispute, and vitriol abounded between the two camps. And now none of us care. Most of us probably don't even know what that is. If you know what it is, it's probably like one sentence from AP US history. This was a huge dispute that helped define our nation's politics for a generation, and now it is long over. The institutions that helped mediate that dispute are still with us. And years from now, God willing, we will have resolved our current disputes, and the American people will be fighting about a whole new set of issues. And if people do feel strongly that a particular issue should be insulated from public debate, they're free to constitutionalize it. But that's through the proper means. It involves a lot of work and not the shortcut of loading a court with a few friendly votes. This, by the way, is why original public understanding originalism is the best method for resolving constitutional ambiguity. It's not because the people who wrote the Constitution were superhuman geniuses or the people who wrote the amendments were superhuman geniuses. They were an impressive group, but they have no supernatural authority on us over the centuries. The reason original public understanding matters is because the public's agreement through ratification is the power that animates the law. What people understood the law to mean is what they voted for, and their votes made it matter. Their votes are the difference between mere words on paper and transformative rules that impact us in the physical world. Now, ideas can have consequences in a broader sense, but laws, empowered by the authority of the people through the processes that we establish, can have very specific consequences in a predictable fashion. So popular sovereignty is one key component of the rule of law in America. The law comes from the people. But popular sovereignty by itself is an insufficient condition for human flourishing. The unrestrained id of a nation can pivot radically toward destabilized institutions and oppression of the minority. We see hints of this in the wild oscillations of the administrative state as each presidential transition brings a dramatic reworking of the regulatory landscape. So to keep the people in control while checking mob hysteria, our founders followed the lead of Locke and Montesquieu by dividing power. And as you are very well aware, we have separation of powers between branches, the legislative, the executive, and the judicial. The legislature has to be careful passing laws because it can't control how they're implemented or interpreted. The executive depends on the legislative branch for funding and for authority, Without authorization from the legislature, there are very few inherent executive powers. And the judiciary is famously the least dangerous branch. With neither the purse nor the sword, its authority depends entirely on its legitimacy. We'll talk about that a little more in a minute. We also have our very clever vertical separation of powers, with separate branches at the state level as well. The federal government is the superior government, but it's a limited government. It only has the enumerated powers, while the plenary police power is reserved for the states. The relationship between the different federal, state, and branches is one of dynamic tension. In theory, each branch jealously guards its prerogatives and pushes back against overreach by other parts in a way that keeps the overall structure steady. Whenever I sue the federal government on behalf of Tennessee, it's not just a fight to win on a given issue. It's also a corrective mechanism to sustain the republic by keeping the federal executive in its lane or by reinforcing limits on congressional power. And as I said, the tension is dynamic. In the middle of the last century, we saw a significant power grab by the Supreme Court. Emboldened by righteous and constitutionally grounded civil rights decisions, the court continued to flex by taking on a variety of social ills. Radical solutions were considered to this overreach to restore the constitutional balance, but ultimately it was solved through a shift in judicial culture, driven by a shift in judicial personnel and by fierce and effective advocacy. And if you doubt the effectiveness of that advocacy, consider Justice Kagan's observation that we are all textualists now. That was emphatically not the case when I was born, and it wasn't that long ago. The people had a long debate, the political branches prioritized fixing the court, and we now have a court that exercises great restraint about constitutionalizing policy disagreements. And I say, as a defendant who personally benefited from that approach, good. Another problem that the judicial maximalist court spawned was aggressive oversight of the regulatory process. Courts would intervene in federal agency processes to promote favored policy goals. And in response, judicial conservatives championed the Chevron doctrine that demanded that courts defer to agencies. The idea was that because agencies were responsible to the president and the president was elected, this was a more accountable way to do business. But of course, we saw one elitist power grab lead to another, as the federal agencies showed that they were not always responsive to oversight. The agencies leveraged the court's deference to grab power well beyond what their enabling statutes allowed. The agencies ended up making huge policy decisions without regard for what Congress wanted. The solution to one generation's problem became itself a major problem for the next generation. And the recourse for the American people was again to identify and debate the problem, to make its resolution an electoral priority, and to emphasize the issue in the judicial appointment process. One Loper Bright later, and we no longer worry about agencies running our lives. Agency attempts to rewrite the law, for example, the Biden administration's Title IX rule, can now be decisively ended by states like Tennessee, equipped with the case law to protect their sovereignty. Both court overreach and agency overreach are counter-majoritarian elite moves. Each is a form of class warfare in which the professional managerial class seeks to entrench its primacy. But while our system needs a capable elite, they are always checked by the people. The counter-majoritarian mechanisms in our system can disrupt or delay, but they can't create. The power lies with the people through their elected representatives. And this can be frustrating sometimes. Concentrated power lets a few judges or a few bureaucrats make quick decisions. It's efficient, but it's fundamentally un-American. It attacks the foundations of our national institutions. And when these foundations crumble, when the people feel like they are not ultimately responsible for the decisions being made, and when a small group of people exercise power without meaningful accountability, the edifice begins to collapse. People feel alienated from the law, which means both that they're increasingly less willing to be bound by it and increasingly less inclined to fight for it as a matter of principle. When the system's functioning and the government reaches a position someone disagrees with, they can call their congressman and complain. They can vote, they can run for office or campaign for someone else running for office with the hope of changing things. And if that doesn't work, at least they know it was a fair fight and they had a chance. When judges and bureaucrats are making policy decisions, there is no obvious recourse. With bureaucrats, of course, a presidential election can potentially move the needle, but that escalates each presidential race into a winner-take-all contest with unreasonably high stakes. Does that sound familiar? And when judges constitutionalize their policy preferences, meaningful response can be at best a generational project. The concentration of power, incidentally, is not just a problem in the public sector. Consolidation or collusion in the private sector can work a great deal of mischief, particularly if the affected industry has a major impact on day-to-day life, such as communications, finance, or media. Prior to Elon Musk's purchase of Twitter, for instance, a thin West Coast monoculture controlled our public debate. Predictably, this power was abused, and that was bad for the republic. Similarly, concentrated power in corporate ownership by a handful of asset managers led to near universal adoption of ESG requirements that seem more responsive to neo-religious obligation than fiduciary duty. They engaged in what was functionally policymaking, but without any of the accountability that comes with passing a law. In a more competitive market, companies worry more about surviving and profiting than about imposing their views on consumers. And even in less critical sectors, such as ticketing and live entertainment, a failed market structure can cause a lot of pain for consumers. Our laws give us tools to fight that. And if you feel this stirring your blood and think you might be a budding antitrust lawyer, we are hiring. But back to the concentration of power in government. It looks like shifting all meaningful decision-making to the executive branch is contributing to unprecedented polarization in our country, not seen since immediately before the Civil War. And that's especially true in the era of social media. And this is the peril of faction that the Federalist Papers warned about. Everything is reduced to a 2-by-1 matrix. Does this help our guy, or does this help the hated other guy? If we don't get back to an issue-driven conversation, it is the death of the republic. Polarization diminishes accountability. Political figures right now can get away with all sorts of stuff because what are you going to do? Vote for the other side? The other guy's crazy and evil. So graft and grift and corruption flourish on both sides. In addition to promoting corruption, polarization stunts competence. Subordinates are chosen for loyalty over capability. People who followed a missional call to public service become cynical and disillusioned, or they get purged. So the ability of the government to do basic governmental things fades, and this reduces the overall legitimacy of the government since it can't do the basic things that it promises to do. And polarization cripples our ability to solve problems. The creative back and forth across the aisle to find a workable compromise happens less and less when the people in office get branded as traitors for talking to the people on the other side. And this delegitimates government. If people are paying their taxes and things just keep getting worse, what's the point? The evils of polarization boil down to short-sightedness. We, as a polarized polity, focus on short-term moves that maximize our position and minimize the other side's. The better course is to look out for the long-term well-being of the nation. In the long run, we are all better off that way. That means strengthening our institutions rather than weakening them, at least most of the time. It means recognizing that our disagreements matter, but that Americans have disagreed about big things for a long time, and will continue to disagree about big things, hopefully for a long time to come. There's more to our history than right now, and there's more to our future than the next election. Polarization comes at the cost of perspective, and perspective is what we need as a populace for optimal self-government. And the law, too, suffers when short-sightedness abounds. Ultimately, the rule of law is about the future by way of the past. Under the rule of law, you know what to expect in terms of process and principle. You can look back at earlier cases and have a good idea of what's coming. But in a hyperpolarized system, people are willing to sacrifice that stability and predictability. Thus, you get insane nullification arguments. You get judges ignoring clear black-letter precedent via appeal to nebulous higher principles. Think of any other example you like. Every principle must be sacrificed for the sake of immediate partisan gain. And so we tear down our institutions that took centuries to build. Building those institutions was hard work. The nuanced institutions of our Constitution are a direct continuation of a long series of efforts and sacrifices, and as a result of that long arc of history, we are the most materially prosperous nation the world has ever seen. We're the most free, too, although cultural tides often threaten that status, and we have to remain vigilant. And here's a prudential note, too. Judges and lawyers blasting through legal constraint to get what they want in the short term comes at the expense of the legitimacy of the law, which means in turn that judges and lawyers will have less influence in the future, maybe much less. So not only is preserving the rule of law in the nation's interest, it's very much in our professional self-interest. And if you're going tens or hundreds of thousands of dollars into debt to enter the legal profession, consider criticizing rogue judges galloping toward anarchy as they stick it to politicians you dislike. They are reducing the value of your law degree. The law was built, and it continues to be built. It performs an extraordinary function. It gives us a reliable framework to deal with disagreements so that most people can focus on other things. We, the attorneys, give people this gift by going to work every day. We give advice based on the rules. We sometimes help clarify those rules. We participate in the adversarial system that promotes transparency, accountability, and quality. And win or lose, a well-tried case reinforces the broader system that makes everybody better off. And sometimes our work touches on the overarching governmental architecture that allows all of this to happen. The courts, the legislatures, the will of the people is expressed today, and the will of the people baked into the deep structures of checks and balances. The friction between the many institutions of government done right will in the long run make everyone better off. But like other infrastructure, like bridges and roads, and as the poor souls in the DC area were recently reminded, plumbing, legal infrastructure needs constant maintenance. We need to shore up the rule of law so that the benefits we received continue for today's children and tomorrow's children and generations yet to come. It is an act of love and gratitude to do our part and to pass it on. Briefly then, how do we shore up that infrastructure? The immediate answer is we respect our institutions, we don't take steps to undermine them, and we applaud those who do right by the law despite the pressure on them to do otherwise. But there's something more fundamental that we need to do. We need to reinforce our ability to be a self-governing people. We need voters and future voters to understand why we have the institutions that we have and how they work. We need them to be able to understand issues and not just root for red or blue. We need them to know that each one of them is the heir to this great inheritance, and each one of them has a central role to play in its ongoing operation. So I leave you with this charge. Leave the law better than you found it. You have been blessed with a gift millennia in the making, and you have the opportunity to make it even better for those yet to come. I have no doubt you will. Thank you.
So thank you, General Skrmetti, for a bracing diagnosis about whatever ails us in our legal governmental systems and the rule of law. I think, I feel sure this lecture has sparked some questions. And thank you for being willing to take them. I must say, this is an auspicious beginning for the Luther Strange lecture in public service, and so thank you again for being with us. If you have a question for General Skrmetti, again, raise your hand and he'll call on you. Please use your microphones, and I'll stand back up in a minute when we're out of time. But thanks again for a wonderful lecture this afternoon.
Thank you, Dean. It's the danger of giving a philosophy major a law degree. Yes, sir.
Thank you very much, General Skrmetti, for coming to our law school today. I had a question kind of touching on your speech. So going back to the rule of law, public polling has shown that young people in America today really just don't believe or care about the institutions. It goes back to the Nietzschean, like, might makes right mentality, the idea that the institutions aren't working for me, so I should just tear it down. How do we go forward from that? Like, we've seen in the past few years a number of incidents on both left and right where people are just taking matters into their own hands, you know, doing things that are just unspeakable, obviously, to the people they don't care about. It seems like we're heading towards like a point of no return, really, in America. And what can we say to our fellow young people to just bring the temperature down and like make sure that these trends don't continue into the future?
So that's a great question. I think the number one thing that we can do is give people perspective. And so however you can educate them on the fact that like the world is not concentrated on what's happening now. There have been big problems in the past. We've worked through them. They need to understand that even if they're not getting immediate gratification from these institutions, the world that they live in is so much better than so many of the alternatives. Now, that said, we also need to keep working to fix things. The configuration of partisan conflict we have right now is not really geared toward fixing things. And so, you know, we need more people to speak out, finding creative solutions. We need more people to clearly identify where institutions are failing and provide a path forward. I mean, we do have complex bureaucracies. We do have complicated laws, and that can be frustrating sometimes. There's a reason for it. Sometimes you look at the reason, you realize, okay, we're kind of stuck with this. You know, standing's one example, where a lot of people think, well, it's stupid that the court won't take the case, but there are really good reasons related to separation of powers why it won't. The more we can explain, the better off we are. And there seems to be a hunger out there for understanding. I mean, people listen to really long podcasts about really, you know, esoteric and obscure stuff. If everybody can just start injecting a little bit of constitutional law into those every now and again, it'd go a long way toward fixing things. Yes, sir.
Thank you for coming, General Skrmetti. Do you think the decreased autonomy of U.S. attorneys' offices strengthens or weakens the rule of law?
Well, I think it weakens the operational effectiveness of the Department of Justice. You know, the trend of trying to centralize control over the U.S. attorneys' offices goes back a ways. I was in AUSA when there were some significant steps along that route. And, like, you can understand why AGs and DAGs want to have more control, but the more control you have, the less time there is for actually doing prosecution. And 99.9% of the cases that come through U.S. attorneys' offices are just bread and butter criminals. There's not really a political valence to it. Most people don't care that much about it unless it's a particularly horrific crime. It just needs to get done. And so the more politicized the DOJ is, and the more hierarchical the focus is on exerting control and micromanaging, you know, you're losing institutional knowledge as senior people get sick of it and leave. You're not doing as many cases, which means there's more crime out there. And it's bad in the instant, and it's bad in terms of degrading future opportunities for DOJ to function. And again, like, this is a trend that's been going on for a while. You know, it seems to be kind of coming to a head, and part of the reason is intransigence by career folks. You know, part of the reason is every last thing is way more political than it needs to be these days. But we're going to have a big relearning, and it's going to take a long time to rebuild DOJ to have the capacity that it had in the past. I mean, that's like, it will not happen in my lifetime, I expect. But it's important. DOJ does all sorts of really important stuff that a lot of people don't appreciate. And if it doesn't get done, folks are going to start noticing. Incidentally, one corollary to that is, as the DOJ isn't able to do as much or isn't interested in doing as much, the states have a huge lane to do more. So in consumer protection and antitrust enforcement, for instance, if the DOJ has fewer people working on it, or if the DOJ has other priorities, the states can step in and do that work. And if you're interested in doing that work, we are hiring. Yes, ma'am.
Hi, General Skrmetti. I just had a question to your point about originalism, and I totally get your argument, but you know, to your point of the votes are what gave the amendments power in the first place. Well, the people who voted those original amendments, you know, who constructed the Constitution, what America is looks different, right? If the laws are for the people, well, who's even considered a person has changed over time. So a lot of the sentiment has evolved. I'm not saying that they were wrong, but like, what is your response to that?
Yeah, I mean, the response is, what's the alternative? as the voting population has grown, I mean, we've had some really significant historical events that have ensured more people can vote than could at the founding. We're still operating under the same architecture. And if you want to go back and say, well, it doesn't really count because, there were a smaller percentage of people voting, then do you replace it with whatever a couple judges think is the right answer? I mean, that's got a real legitimacy problem. So we have corrective mechanisms built in to the system, and ideally, we have a constitution that's more focused on providing structure and setting guardrails with a lot of room for robust democratic debate in the middle. And so the less heavy-handed the constitutionalizing is, the more opportunity there is for the broader voting populace to make more of the decisions. I get the argument. I mean, you really can't say otherwise. It was a very different voting population that ratified the Constitution, but it's still the same Constitution that we have today. And so the best way to understand what it means is to look back at what was voted on. Yes, sir.
So the conflict between state and federal governments is written into the Constitution. It's not a byproduct that's accidental, but the sky's always falling, and I'm not the only one that seems to think that sometimes. And you just turn on the news, you see the conflict between state and federal government all the time. You see it in Minnesota, you see it everywhere. What is the current conflict between state and federal governments? Is that, in your opinion, any different than what we've seen historically, or is it ramped up in an over-politicized environment? Just what are your opinions on that?
Yeah, I think it's cyclical. We had it nice and boring for a long time, which is the ideal. Like politics should be boring, law should be boring. It was a little bit before my time, but we had the National Guard marching through American cities getting attacked because of disagreements between state and federal priorities. We've seen massive rioting in the past. Some of the rhetoric lately has been very hot. I think if you step back and look at what's actually going on, there are definitely problems. There are definitely problems, and there's a lot of stupidity in figuring out how to solve those problems. For instance, in Minnesota, so much of the violence could have been reduced if there was more cooperation with law enforcement. I mean, in Tennessee, if someone's got a detainer, there's a smooth process, and you don't end up with the kind of street interactions that you were getting in Minnesota. But that's the state's choice. They're free to choose how they want to do it. The rhetoric about calling up the National Guard to fight federal law enforcement agents is crazy. The threat of the Insurrection Act being invoked is less crazy when you have local government that is interfering with federal law enforcement. But for all the talk, things seem to have calmed down a little bit. I feel like there's a lot of performative conflict, and certainly there are people who are dead. There are real issues going on there, but it's not that far out of the realm of what we've seen historically. I think the biggest part of the problem is we don't know history anymore as a people, and so folks see this and think, my goodness, never seen this before, because they don't know what happened in the past. And we've gotten through hard times in the past. Ideally, we'll get through hard times again. There are real strains on our institutions. We're dealing with technological pressures that we've never seen before. But America's been through a lot of hard times. The Depression, you look back at what happened then, it's insane. The Civil War, it's way worse than we have it now. We have the capacity to get through this. We just have to have, I think more than anything, the perspective. Hostile questions are welcome. We'll make sure you get your money's worth. Yes, sir.
So thank you again for being here. If democratic legitimacy is really what it boils down to, how do you feel about redistricting, off-cycle, gerrymandering, the ability of minorities to exert undue influence over the legislative process?
So, I think over time it's less of a problem. It depends on how tribalistic we really are right now, but I think if you look at the Trump-Biden-Trump move, it shows that people aren't locked into their parties, right? It's not an indelible part of who you are, and voters respond to what's going on. So for all these big gerrymanders, in the short term, I have very low expectations for how the Republicans are going to perform in the midterm House elections. But if Virginia's a 10-1 state, at some point that is going to bite the Democrats hard, because a little nudge and all of a sudden you've got like a 6-5 delegation. So, you can try to grasp at what you can get, but the further you try to gerrymander, the bigger the risk there is. And the American people tend to come back relatively toward the middle. So, I think it's a risk calculation. I think people are so focused on the short term that they're going to learn that, red and blue are not etched on our souls. And if one party's not performing either in a state or nationally, they're going to pay a price for it. We're so focused on turnout, and that is important, but people can change their minds too. Yes, sir.
Thank you, General, for giving your wonderful speech, and thank you also, General Strange, for starting this new tradition as well. I'm going to ask a question that I think will not get necessarily pushed back from you, but I am sitting between two federal judges, so I'll try to be careful in how I phrase it. You clerked for a really brilliant guy, Judge Colleton, who I don't know if you're aware of, has visited with us here at the law school.
I didn't know that.
Before. So I guess my question for you, I agree with you. There's a self-interest to be had by the judiciary for getting the house in order a bit in terms of legitimacy, what have you. I was kind of wondering if you were having a conversation with your old boss, what you might suggest is other ways that the judiciary might be able to police themselves a little bit and deal with some of the issues you're talking about.
So, a lot of us have been racking our brains about what the solution to some of the road district judge issues are, because despite CASA, you still have functionally nationwide injunctions going on. I recognize there are big, hot political disputes, but there are judges who are just straight up ignoring the law. Like, nobody with a legal education and a United States code in front of them could possibly think that there's a legitimate legal justification for some of the decisions that we've seen. I think the judiciary needs to name and shame. I think the courts of appeals need to start intervening if a repeat offender starts acting up again, and just take the case away and reassign it. There may need to be additional steps beyond that. I don't think we need to get rid of life tenure. I think that's really important. It may be that we need to look at forum shopping more, because all these cases come out of the same places. And to be totally fair, you see the cases come out of the same places on the other side. We were very cognizant of the inclinations of different districts. As people look at how to execute on legal strategies, that's a really important part of it. But, where we're at now, I think the judiciary has a huge role in overseeing rulemaking by the executive branch. And I think it's really important that the judiciary keeps doing that, in part because the federal regulatory apparatus has really started to bleed into the legislative power. And so the courts have all kinds of license to step in there. But there's also just the nuts and bolts executive branch stuff. The president needs to be the president. It doesn't matter if it's someone you like or not. The country needs a president who's able to execute the laws, who needs to be able to manage the executive branch, deal with personnel issues. And I have told some of my colleagues on the other side, if you shift the focus away from the rules you don't like and just start trying to interfere with the day-to-day business of the executive, just know that the next Democratic president won't be able to unlock the front door of the White House. The precedent getting set here is terrible. where it's just like kneecapping people for the sake of hitting your partisan adversaries. So I think one thing the courts can do is draw a really clear line between executive branch things that are really squarely in the executive branch where the courts absolutely should not intrude versus, the executive branch imposing obligations on private parties where there's a lot more room for judicial intervention. But one way or another, the courts need to get their house in order because this is, potentially an existential problem for the country if we don't fix it. But I think we will fix it.
I know some of our students have 1 o'clock classes, but I just want to once again thank General Skrmetti for an incredibly stimulating discussion. To our students, y'all are the future. People my age have left you a big mess to deal with. And one of the things you'll get to do is spend your life trying to figure out how to make it better. General Skrmetti, I can't think of a better way to have kicked off this lecture series than with your remarks and the great discussion we've had today. Thank you again. You've honored us with your presence this afternoon, and we're so grateful that you chose to come down and spend President's Day in Tuscaloosa, Alabama. So join me, if you would, in thanking General Skrmetti.